Our court case was Regents of University of California versus Bakke, brought to you by Noah Cook, Trevor Faust, and Saif Akram.
Okay, so the facts of the case were that it was decided in 1978. The whole case kind of revolved around Allan Block. He was a 35-year-old white man who applied to the school twice and rejected both times. Not only the problem with this case was that he had been rejected due to a quota system. So he had higher requirements than minorities that were getting into the school, but because of the quota system and he was being basically pushed out and having a very big disadvantage. And the quota system basically means a reserve spots just for minorities.
So the constitutional issues were that the University of California's Davis School of Medicine policy of affirmative action violating the 14th Amendment said that all persons born or naturalized in the United States, it forbids any state to deny any person of life, liberty, or prosperity without due process of law. It also said that an affirmative action violates the Act of 1964, which ended racial segregation in public facilities such as employment and voting facilities.
Okay, so even though the majority was against the quota system, there was a few opinions that why the quota system actually helped, and that was the increase in diversity in schools, and also those from like difficult backgrounds might get a greater chance at higher education, but it's not always the case that they might be from difficult backgrounds. Um, and you'll see later that in a case later, the Grunter versus Bollinger, that there was a kind of a down version of the affirmative action, which actually helped minorities get a slight advantage in the college admission process.
So the conclusions pretty much stated that the the Quota Act was unconstitutional for the school. The decision was 8-1 in favor of Bach, and the Supreme Court's final decision was that the University of California had violated the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964. Therefore, discriminating race to promote diversity is unconstitutional.
Okay, so as you had talked about before, the Grunter versus Bolling case was actually used our case as a precedent, and they ruled again. They used the Equal Protection Clause of the 14th Amendment as well as Title VI of the Civil Rights Act that having the quota system was unconstitutional. But again, as we talked about in the previous slide, the minority still, as a compromise, got a slight advantage in the college admission process.
So the problems were that it was kind of difficult to find a dissenting opinion, and it was also difficult to finding a case which used our case as a precedent, which was kind of like an outline for our previous case.
And the reason that the dissenting opinion was a little difficult to find was because there was a quite an overwhelming majority that were going towards the court system being unconstitutional, and really this one case that we found was the only one that was used as a precedent.
Yeah. And here are our works cited.
Okay, thank you for watching. Bye.
Bye.